Welcome, everyone. Thank you for joining us on this quick 15-20-minute seminar regarding layoffs and how they may impact your immigrant and workers. I'm Roger Tsai, attorney here at Holland Hart.
I'm Sarah Bileti. I'm also in the Business Immigration Practice Group here at Holland Hart.
And we're going to talk today about the various immigration statuses and how they may be impacted if there's a layoff. And I recognize in the current situation and current facts, current environment, quite tenuous for a lot of workers, particularly tech workers. So we're going to try to address some concerns that we've heard from a lot of immigrant employees and also HR managers who directly deal with immigrant employees. So first, we're going to talk about what is the impact to employees. And this is largely going to depend on what is the immigration status of the immigrant employee themselves. So for example, F1 international student graduates, they often will be under a status called OPT, optional practical training, and those individuals are permitted a 90-day period of unemployment. And so that's a cumulative period throughout their 1 year of OPT. For those who graduate with a STEM major, that's a 2-year additional work permit timeframe. It's called the STEM OPT. Those individuals are granted 150 days of cumulative unemployment timeframe. And so those are kind of the timeframes that the immigrant employees and you will want to keep in mind. Note that if somebody is laid off during that OPT or STEM OPT period, they can find another employer to quickly transition to. Typically, they may want to coordinate with their international students office to notify them of that new employer, but that's a fairly standard process. For a lot of other work-based visas, so I'm talking about the alphabet soup of immigration visas, Es, H1Bs, L1s, TNs, these individuals are permitted a 60-day grace period. And that 60-day grace period was created based on a USCIS regulation in 2017. So what that means is from the date that somebody is no longer working full-time in that particular, let's say, H1B position and not being compensated, that begins this 60-day period in which they are intended to wrap up their affairs and eventually depart the United States. So I also want to discuss kind of what is the ability to transition to a different employer. And largely that's going to depend on the type of visa. So for example, an F1 OPT, STEM OPT, they already have a work permit. So in general, there's no additional work permit application that needs to be submitted or any affirmative notification that needs to be submitted. However, on the other hand, if you're under an H1B visa or a TN or an O1, those typically will require affirmative notification and specific filing. It's called an I-129 petition with the government. And so that's something to keep in mind because that will potentially slow down your ability to absorb that new worker. I'm going to briefly pause and turn over to Sarah and see if she has thoughts and also let her address kind of some other additional H-1B related issues.
Thank you. Yes, I think the one other thing that we've been asked a couple of times lately in the context of a reduction in force or a layoff, if there are foreign national workers who are impacted by that layoff who have, for example, pending H-1B cap cases right now that will become effective on October 1st. The sort of burning question to those foreign nationals is, can I transfer that H-1B cap petition that's pending to a new employer? And the answer, I think, is maybe, but traditionally, usually if you're in F1 status, whether it's OPT or CPT, and you're awaiting an H1 cap approval that will become effective on October 1st of that particular year for H1 status, the kind of conventional wisdom is you can't transfer a status that you don't yet hold. So if you're separating from the employer before October 1st, the sort of normal thought would be that no, it's not possible to transfer that H-1B status to a new employer because you aren't going to be with your current employer on October 1st. That said, I think it may be possible for a new U.S. employer to make an argument and file a new H-1B petition for that person that the person was already counted against the cap. So that wouldn't be an H-1B change of employer petition per se, but it would be a new H-1B petition by that new employer with the argument that that particular individual had been counted against the cap. I haven't done this personally. We were talking about this before. I think you said you haven't either, Roger, but I think in a situation where there are no other options, it may be worth a try to see if USCIS would approve that, which in this current year in particular, it's so lucky to be selected for the cap that it would be really heartbreaking for an employee to not be able to take advantage of that because they were laid off prior to October 1st. So it may be worth a try.
Great context, and yeah, very appropriate given the 17% rate of selection. Um, I think in those situations, you'll certainly want to make sure that the immigration attorney who, for employer A coordinates with employer B. So anyways, there's a sort of a clean handoff there in terms of information and also immigration status. Great. And moving forward here, just a little more context regarding H-1B workers. With H-1B workers, there's actually specific steps that have to be undertaken to properly terminate an H-1B worker. When I say the word terminate, I'm typically suggesting when an employer makes the choice to end the employment of an immigrant employee. Note that I would suggest that these steps be taken even if an immigrant employee is voluntarily choosing to resign his or her position, because you never know what the immigrant employee could accuse the employer of later on. Constructive termination is another sort of factual charge that might come about. So anyways, in order to effectively terminate an H-1B worker, 3 steps have to be undertaken. And if you don't take all 3 steps, technically the employer is still required to pay the H-1B wage. So unless you do all 3, you have to keep paying, and the Department of Labor will make you pay back wages. So number 1, you need to notify the U.S. of the termination. And so typically, for example, if there was an approval notice that was issued by the California Service Center, you need to notify the USCIS California Service Center of the termination of the employment. And they will typically take a couple of months, but they'll send a confirmation that that H-1B has in fact been terminated. The regulations also require an employer to notify the immigrant employee in writing, which I'm sure is part of a normal employer's protocol. And lastly, there's kind of this unusual requirement to offer to pay the return travel costs back to the immigrant employee's home country if in H-1B status. So what does this actually mean? So this means an employer is offering to pay basically a flight ticket for that immigrant employee, not their dependents, not moving costs, back to their home country. So maybe that's $1,000 or so. What we find in 95% of cases is essentially the immigrant worker, the H-1B worker, will want to stay in the United States. So they don't want to take your money. They'll want to indicate that they'll want to remain in the United States. But we just want to confirm in writing that that has in fact been offered to the immigrant employee, as that is a trigger, or effectively one of the elements required to effectuate this proper termination. I would also just mention, to the extent that there's any change in material conditions, such as a decrease in salary or hours. So for example, if you're having some level of furloughs, that would also be something that would need to be affirmatively required to be notified to the immigration agency. So even if that's a decrease of $5,000, $10,000, or other material changes in that person's position. So something to keep in mind. Many of these individuals under H-1B status may also have a green card process, permanent residency underway. And so, Sarah, can you talk to us about what will it take? How will this layoff process impact perms and green card processes?
Sure. I think it has quite a few different impacts. First, I want to talk about the impact to the employee. So if an employer has a employment-based green card process ongoing for a particular employee who is then laid off or terminated, depending on where the employer is in that employment-based green card process determines what the individual can maybe transition with them into their new role. For example, if an employer has initiated the perm process for an employee, but they're only partway through that, say they might have been to the point of a labor market test when this layoff occurs. In that case, if the employer never got to the point of filing an I-140 or had an I-140 approved, the employee can't really transition that progress to a new employer because the perm process is specific to the petitioner, which is the employer, a job title, a job location, and even a wage that's determined by the Department of Labor that's only good for a certain amount of time. So progress in that perm, that step one, can't really be transitioned by the employee to a new employer, and they've then kind of lost that time. If, as I alluded to, the employer has been through step two of the employment-based green card process and has filed an I-140 for the individual that's been approved, then the employee is in slightly better position in that I-140 approval, they retain the priority date that's noted in that I-140 approval, and that can be transferred to future I-140s that would be filed through their next employer. So that helps because that secures the employee's position in a waiting line to be able to file the third step of the employment-based green card process, which is a I-485 application for a green card. The other benefit of the I-140 being approved is that a new employer can continue to extend that person's H-1B status beyond the 6-year maximum, even though it's not their I-140 for them. A previously approved I-140 allows that. The employee will still have to go through a new perm and I-140 process with their future employer, but there is then no urgency to do so. It could be that next employer, it could be the one after that, depending on how long they have to wait before a priority date is likely to be current. So that's sort of where that falls. In terms of having a pending I-485 application for a green card, it depends on how long it's been pending, in the sense that it's more useful to the employee if their I-485 has been pending for at least 180 days while they've been employed with that employer, because then they might be able to port it to a new employer. If they have a pending I-485 that's been pending less than 180 days, then portability may not be an option, and they would instead have to go through an H1B or underlying non-immigrant transfer of employer, rather than relying on that pending I-485 and I-485 portability. In terms of the perm process and the impact of layoffs to the employer, that's also something important to consider and something that has had big impact in the current market conditions, because a layoff may mean that the employer, if they have ongoing perm processes and labor market tests in process, that they may have to disclose when they file that perm application that there has been a reduction in force or a layoff within 180 days of the time of the filing of that application. And if that's the case, the employer has an obligation to affirmatively notify any impacted U.S. workers that are working in the same or a related occupation. The DOL doesn't define exactly what's required with this request to notify impacted workers, but the burden is on the employer to be able to demonstrate that they've met this requirement in the event of a Department of Labor audit. So I would strongly recommend to do it in writing to those impacted workers so that you have proof that you affirmatively reached out, invited them to apply for the perm role, and then properly screen them out according to the same procedure that you used for all other applicants to the perm role. It is also very likely that indicating that a layoff occurred within 180 days of the filing of the perm application could trigger an audit. And the Department of Labor monitors those things not only through how employers answer questions in the ETA 9089 form, but also through the WARN Act notices about ongoing layoffs and reductions in force, because employers with a certain number of employees are required to make those disclosures to the Department of Labor.
Great. Helpful takeaways. And if I'm hearing you right, I mean, essentially those individuals, how immigrant employees are impacted through a potential layoff. There's many different sort of layers of the impact, but generally, the further along somebody is within that green card process, the more likely they will be able to take some of the prior green card progress that they've made. Is that right?
Yes, that's exactly right.
Okay. And then in terms of like that labor market test, right? It sounds like, yeah, it's hard to assert that we can't find a minimally qualified U.S. worker when we are laying off U.S. workers potentially. And so I think you nicely point out kind of that contradiction and kind of how an employer might navigate that.
Yeah, there are a couple of nuances to it that I think it's important. Like if you have a reduction in force and you have ongoing perm processes, that it's wise to consult an attorney because there's an analysis that can be done whether or not the laid off positions are the same or a similar occupation and also in the same area of intended employment as the perm position. Because if you're laying off workers in Buffalo, New York, but the perm position is based in Los Angeles, California, and you're conducting recruitment out of Los Angeles, California, then that's not a layoff in the area of intended employment. So there are some nuances to it. There are also some nuances about what's considered a layoff or an involuntary separation because a termination for cause or for like a violation of company policy would not be considered a layoff or a reduction in force. But on the other side, laying off even one worker would trigger this obligation if it's a true layoff or reduction in force.
Fair, helpful. Last point here, I'm recalling, I think you got a client phone call up maybe within the last week or so, talking about benching. You want to kind of address that?
Yeah, the other thing Roger talked about earlier, the requirements with regard to H1B workers in the event of a reduction in force or a layoff. And one question I got from a client recently was regarding, well, can I transition this individual to part-time? Or can, so, and the answer is not without filing an H1B amendment petition, because if the initial underlying H1B was filed for a full-time role, then according to the labor condition application that's submitted as part of that, the employer is required to pay full-time wages to that individual unless and until an amendment is received by United States Citizenship and Immigration Services, indicating that a lower number of hours are going to be sponsored.
It's perfect. Yeah. And I've heard the question kind of mentioned by employers like, well, what if the immigrant employee, they just want to take a bit of leave? I mean, certainly FMLA leave is one thing, but if they're willing to kind of just be unpaid for a while just because the employer doesn't have enough work, that would fall into the kind of that benching category that Sarah mentioned. So, well, great. Sarah, anything else that you want to mention?
I think we pretty much covered it.
Awesome. Okay. Well, thank you for joining us on today's quick, short take regarding immigrant layoffs. And we will have another webinar. This is kind of a full-blown hour webinar on I-9 forms, e-verify, those sorts of questions. It's going to happen on Wednesday, July 19th. Would be happy to have you join us. And so feel free to register for that. If you have any questions in advance of that, feel free to email either Sarah or myself. Be happy to address those within the webinar. Thanks and have a great day.